I found the right password. Thank you to Ms. Jones. How's everybody doing today? Good, good. Apologize for the delay. It looks like we are all here. And with that, Ms. Jones and Ms. Solaria, do we have to open up the meeting with a roll call and all of that logistics? Is that appropriate, or how, can you just remind me?
Yes, Chair Sweeney, I think a roll call is appropriate and we can get that on the record.
Great, great. Ms. Jones, would you mind doing a roll call for us?
Absolutely. Good morning, everyone. We'll start with Member Bitzer. Are you present?
I am present.
Good morning. Member Cates? Member Duval?
Present.
Member Garcia?
Here.
Member Honker?
I'm here.
Vice Chair Trujillo Davis?
I'm present.
Chair Sweeney?
I'm present as well.
Wonderful. You have a quorum. One member is not signed on yet.
Okay, thank you so much for that, Ms. Jones. And good morning, board members. How you doing? And I appreciate everybody coming on today. And we just wanted to maybe start out the meeting, our deliberations today, with a couple discussion items of logistics and scheduling, just to make sure we get everything on the record. So first few minutes of our meeting, our deliberations today, we'll do that. So with that, Ms. Jones, actually, do I see, I don't think I see Hearing Officer Orth. Is she on?
I'm here, Madam Chair.
Oh,
I'm the second Pam Jones.
okay. All right. My stomach almost dropped there when I didn't see your name up there.
I cloned myself.
Thank you.
I was wondering about the two Pam Joneses.
Thank you, everybody. And I just want to also thank Ms. Jones and Ms. Corral and Ms. Our hearing officer, Orth, and Ms. Solaria for all of their work. And of course, our court reporter for supporting our board through the deliberations in preparation of all the logistics. As we all know, this WebEx forum isn't the easiest, as I can attest to this morning, trying to figure out which password to use. So thank you so much. And with that, I'll reach out to Ms. Orth and Ms. Soloria for any initial logistics that we want to discuss with the board or inform the board of.
Madam Chair, this is Felicia, and I just wanted to say that if there is a question from the board members as to a particular record citation, I do have the transcripts at hand, and I can reach for other items in the record, and I'd be happy to help answer questions you might have about the record. I will not obviously be offering you any legal advice. That is Ms. Solaria's task. And I am prepared at the chair's request to bring up each section of attachment A, which is the expanded rule, if you will, with each of the parties' final proposed language. I am prepared to share that on the screen as you discuss each section, so that people following along can see exactly what you're discussing.
Thank you so much, Hearing Officer Orth. Do any of the board members have any other questions for regarding what Ms. Orth shared with us? Yes, Mr. Hunker.
I just wanted to say thank you, Ms. Orth, for all this work and for putting it together in this format, which I found very helpful, as well as your little shorter introduction. So thanks for that. That's been very, very. I mean, it's not easy to go through, but it's well organized. So thanks.
Thank you.
Thank you, Member Hunker. And I'm looking out here. I think, let's see, and then I'll look to Miss, is that all for right now, Miss Orth?
Yes, Madam Chair. Oh, I wanted to mention that I did invite all of the parties to identify errors in the compilation if they found them, because it was a long document and it was entirely possible I had made an error. The only communication I received along those lines, I believe, has been forwarded to you. Kinder Morgan reached out. They wanted the exact language in a proposed SOR in connection with section 113B 10 and 11, paragraphs 10 and 11. So I forwarded that. It's, I believe, the same information that's in the report, but it is in the SOR language that they believed important. So that was the only communication I got from a party.
Thank you for that, Miss Orth, that update. All right, I want to make sure we put on the record that we have Member Cates on the line now. Good morning, Member Cates. How you doing?
Good morning. I was baffled by the absence of information about how to log on. I don't know how you guys did it, but did I miss something?
No, we all had that little hiccup. I did as well.
Oh.
So we are just starting
Okay.
and just going through some additional logistics from Miss Orth and updates. And also we're about to hear from Miss Solaria about any further discussions before we begin the deliberations.
Good morning, board members. Two things. One, just to kind of drop a pin in this. I think towards the end of the day, Madam Chair, maybe we would have a discussion about potential, see where we're at, and then potentially scheduling an additional date if deliberations need to continue. I'll just point out that if we are going to do that, we would just announce that at the end of deliberations on Friday. I think there's concern that we should look at a date further out, considering the number of parties who want to attend and as a matter of public notice. So we'll have that discussion as we go along. And then otherwise, in terms of procedure, I think for myself and also members of this current board, this is the most complex deliberation we've taken part in. So I think the best way to go about it, to my mind, is we just go section by section. Obviously, the hearing officer did a great job of identifying the sections which were not contested, and to the extent that we encounter pockets of uncontested sections, we can take all of those in essentially a line vote to approve them. I just wanted to remind the board members that their decision has to be on record as to why they took that decision. So just keep that in mind. We have this excellent report here to reference points made during the hearing, party evidence that's in the record, parties' proposed statements of reasons. So to the extent that you are discussing a section and want to rely on a particular argument proffered by a party, just take care to do that so that's on the record, and ultimately that will be reflected in your written decision and the records of the deliberation. And I think that's all I have for now.
Thank you, Ms. Soloria. And I think I see Member Bitzer with his hand up. Yes, Member Bitzer. And I think I heard you, Member Garcia, as well. No? Okay, just Member Bitzer. Yes.
So, council, am I understanding correctly then that we have to verbalize our rationale for support of things that were unopposed?
If it's unopposed, my advice would be that your rationale would be that this provision was unopposed and we support it for the reasons proffered by the department. So if you look at attachment A, for example, there are certain provisions where that is noted. There is no contest from, it's not contested by any party, and the department simply has provided its own rationale. And so that would be, the board would adopt that rationale if it's unopposed. And that would be the basis in the record.
Because that'll save us a lot of time if we don't have to read all that, reread all that into the record.
Right. I don't think it's practical or expected that we reiterate the department's rationale if a provision is uncontested by any of the parties presenting testimony. I just think that in terms of having a clear record, and also in terms of eventually drafting the statement of reasons, there has to be a reference in the record as to what your rationale was, even if that rationale was this was uncontested, and so we adopt the department's reasoning for adopting this provision.
Are you the one that has to draft that?
I am the lucky one, yes. So I would appreciate a good record for me to reference. And also, obviously, we want the parties would want a good record so that the board's decision is clear. And the other thing I wanted to point out, just for everyone's information, for purposes of rulemaking under the Air Quality Control Act, a majority of the Environmental Improvement Board constitutes a quorum, so that's 4 of you all, we have a quorum. But any action, order, or decision of the Environmental Improvement Board requires the concurrence of 3 members present at a meeting. So that's a little different from rulemaking in other contexts, and that's a specific carve out that the Air Quality Act contains. So I did want to bring that to your attention as well.
Thank you, Ms. Soloria. Yes, Member Hunker.
Just a procedural question. Does that mean we're going to have to take a vote on every section as we go through it? Or if there are several uncontested sections in a row, could we possibly put them together and vote on them as a group in order to save a little time?
That's a good question, Member Honker. And my recommendation would be to do the latter, in the sense that, for example, there may be sections where there's just a group of sections that were not contested, and we would take that up as a group. I'm obviously open to any suggestions on how to do this more efficiently, but I think that's probably the easiest way to do it and save us a little bit of time.
Yes, I think Vice Chair Trujillo Davis, yes.
Yes, thank you. I just want to make sure I understood that. So if we have a section that is contested and we deliberated at length, do we vote on that section to kind of keep us on track?
That's correct, Vice Chair Davis. I think that, or Trujillo Davis, there are going to be sections that are going to have a more robust deliberation, and at the close of those discussions, we would take a vote on that specific section.
Yes, Member Bitzer.
And along the same thread, when we have one of these votes on something that is uncontested, or a series of things that are uncontested, can we do this by acclamation, or do we have to have a roll call each time? Could the chair just say without objection, and then if there's no objection, so passed?
Ordinarily, I would say if we were meeting in person, that would be fine. But because we are meeting online, and for the benefit of the public and the record, I think we should do a roll call.
Thank you for that clarification, Ms. Soloria. And I understand too, our court reporter we'll be also documenting that for the record, just so that we have everyone's vote in. I know it would be more efficient, but we are having to do this virtually. Does that address your question, Member Bitzer? Okay, Member Cates.
So, just in doing a word search on the appendix or the attachment, whatever we're calling it, yesterday, I just did a simple word search on propose, because that covers a good part of what's being asked, what's being asked by different parties. I got 89 hits. Actually, that's for the word proposes. You just do propose, singular, you get 10. So we're looking at, if my count is correct, we're looking at 89 separate questions. Now, there's some redundancy there because, say, an oil company will propose. So it says an oil company will say, we propose, and then the NMAD will come back and say, so and so proposes. So that is that you see that in some instances. So I think we're still looking at deciding, debating, possibly 70 different points here. And so my question is, how many of those are uncontested? And how many of those appear to be contested? Who knows?
Yes, Member Cates, I know our hearing officer Ortha, if you're on the line, could you just maybe give us a summary, and also for the record today, just so we're grounded in what the task that we have ahead of us?
Yes, Madam Chair, I'll acknowledge I didn't make a count of the different decisions. I would note that some of the decisions you'll be making are relatively minor decisions, say wording clarifications posed. Some of the decisions are quite major, and there's simply no comparison in my mind between deliberating on the question of, well, I think the earliest significant question you'll be asked is whether two counties in New Mexico, Rio Arriba and Chavez counties, should be covered within the scope of the rule. That's the first, I think, really challenging question you'll be asked. Not too long after that, you'll be asked whether, for example, one word should be added to a definition, or 3 or 4 words should be added to a definition, and whether you would find that clarifying or not. So yeah, you have dozens of decisions to make. Some of them are profoundly significant. Some of them aren't. Member
Well,
Garcia.
Member Cates, is it okay, Member Garcia, if we finish Member Cates's question? Okay, thank you.
Sorry.
Member Cates?
well, the kind of information we just heard there should be in the report that was submitted. Now, what we have here is we have 2 documents. We have a report, and then we have a 350-page recitation of the law and the many changes that are in it. And so when I look at the report, this is the kind of information I expect to see in the report itself. And so in over 10 pages, 5 of those are a list of people or organizations. 4 are mostly boilerplate legal language. A couple of things jump out at me from the report, however. One on page 1, if you guys have it, where the officer notes that this has been going on since 2019, so we're now in year 3 of this revision. I mention that because there's timeliness about this that we should be addressing. Another thing that jumped out at me was number 5, or page 5, where it's about 3 paragraphs down. It says it's important for the board to adopt a clear and thorough statement of reasons supporting its decisions in the matter. And I can only imagine what can of worms that it will open for us as a part-time voluntary board to do on 70, 80, 90 questions. And then I look at page, a little deeper into this rather thin document. You look on page, the top of page, the part that talks about attachment to the, so look at the top of page 10, where the hearing officer is taking stab at humor, I suppose, or irony, irony being a close cousin of humor, where the officer says, we're being offered attachment A as a compilation of epic length intended to ease the board's progress through deliberations. A compilation of epic length intended to ease the board's progress. And in the margins there, I wrote, oh, well, that's very funny. However, the joke is on us, and by extension, the joke is on taxpayers, on voters, on the entire citizenry of the state here, because we're given absolutely no guidance on how to proceed through this extremely voluminous document. And so this is all by way of me wanting to make a suggestion to the board that we don't need to grade the report, but I think we can very well stamp incomplete on it and send it back to the hearing officer and ask the hearing officer to give us guidelines on each question and to make a recommendation on each question. Now, if we go back to the time when we had the hearing to begin with, the hearing officer told us she wasn't going to make a recommendation on anything, and I'm not sure that that's her call. And I sense that we have the authority to say, take this back, do a more complete job, and give us something that give us a manageable document. And so that's my spiel, and I throw it open to the board. I'm interested in seeing if anybody thinks like I do.
Thank you, Member Cates. Before we go into a full discussion, I want to look to our board legal counsel, and just maybe explain kind of how we got here, what we have before us, and also some of the timelines that, as Member Cates has pointed out in the officer's report, this has been a long process. I think we're all coming up to speed on that and have come up to speed on that. But could you, Ms. Solaria, just kind of give us your perspective, and then we'll maybe have our hearing officer respond after you provide us that. Thank you.
Thank you, Chair Sweeney. I will echo, to the extent Member Cates referenced what the board's appointment of the hearing officer was in this matter. It was clear from the beginning that the hearing officer would not be making a recommended decision with regard to the language of this rule, which complies with the procedures regarding the appointment of hearing officers for rulemaking before the board. Ultimately, the board, this is epic in length because this is an epic-sized rule, and the board has to do the somewhat tedious task of going through the language and deciding what language they're going to adopt. Ultimately, that decision is up to the board. It was never allocated to the hearing officer and should not be, considering the board's responsibility in this arena. So I think given the breadth of the testimony that was offered and the breadth of the hearing itself, the document prepared as attachment A to the hearing report I found to be incredibly thorough, and distilled the information in a way where the board can weigh the varying arguments. To my mind, there was no other way to prepare this type of report, again, given the number of parties involved, the number of arguments proffered, and just the sheer breadth of this rule. So I think it certainly would have been more expedient if the hearing officer herself had made recommended decisions, but that simply was not her role for the hearing, and certainly was not the purpose of the preparation of the report. The report is intended to, as I mentioned, distill the arguments for and against each version of the rule, so that the board wouldn't have to pour through thousands of pages of the transcript to distill those arguments themselves. So that's really all I have to say on the preparation of the report and the utility of the report for your deliberations.
Thank you, Ms. Soloria. And before maybe a follow-up, a member, Kate, I was wondering if we could hear from hearing officer Orth real quick.
Thank you, Madam Chair. I don't really have anything to add to what Ms. Soloria just said. I am hopeful that maybe after moving through the deliberations, Member Cates finds the format more helpful than perhaps it appears to be right now. The alternative really was for all the board members to juggle 11 post-hearing submittals of varying lengths, which stood about a foot tall in hard copy. That was really the alternative for these deliberations, and that's why the format of the report is that way. And Member Cates, I'm not sure if you were on early enough to hear that as the board proceeds through each section for its decision making, the chair asked that I share my screen with the language under discussion, again, in the hopes that that will make your discussion a little easier.
Thank you, hearing officer Orth. Yes, member Cates.
So when you both just asserted that it's not the hearing officer's role to make a recommendation, and yet we have had many hearings, many procedures where a hearing officer does make a recommendation. Why is this an exception? And who's decided that? Who's made that decision? Is that not a board?
I'm
Well,
sorry.
I
Madam
would
Chair,
like.
Member Cates, a hearing officer recommendation is more typical in an adjudicatory hearing because there the hearing officer is offering findings of fact and often conclusions of law, is weighing the credibility of witnesses, and is very close to the evidence in a way that board and commission members are not necessarily that close. Sometimes the board and commission members, certainly the cabinet secretary in an adjudicatory proceeding, is not going to be present at the hearing. And so in those cases, it can be important for the hearing officer to offer a recommendation, and in particular recommended findings of fact. In a complex rulemaking, though, with potentially profound impacts on our state's largest industry, and I'm an administrative hearing officer with a long career affiliated with environmental protection agencies, natural resource agencies, and I'm not just being modest when I say that I don't think my personal recommendation to this board would be especially helpful in the broad policy making that I know all of you bring to this board. I mean, that's why you were appointed by the governor, was to bring that to this board. And I'm not sure there's any substitute for that. Certainly, I'm not offering that substitute.
Thank you.
So so then it sounds like you're you think of yourself as incapable of doing a more useful summary, or just unwilling? Which one is it? Or both?
Um, ma- Madam Hearing Officer, I just want to make sure that, you know, I think from what I heard, and please correct me, Miss Solaria or Miss Orth, um, it was basically the framework of the hearing officer's task for this particular rulemaking process was slightly different than what we have, and as Ms. Orr said, in the adjudication or other type of decision making process. And is that
Madam
correct?
Chair, that's correct, Madam Chair, and I will add to what Ms. Orr stated to emphasize that the board's rules distinguish between an adjudicatory hearing and a rulemaking hearing, and the hearing officer's duties are distinguished as between those two sets of rules. So for example, in an adjudicatory hearing, where there's one party contesting an action by the department, our rules speak in terms of a recommended decision. There's an actual provision that states the hearing officer report may prepare a recommended decision. That same provision is not present in the rulemaking rules, the rulemaking procedures. In fact, for a hearing officer's report in the rulemaking context, it's stated that the hearing officer shall file a report of the hearing, identify the issues addressed at the hearing, identify the parties' final proposals, and the evidence supporting those proposals. Recommendations can be included at the request of the board, but when this board appointed the hearing officer, that request was not made. And I would state that that is that kind of goes hand in hand with the gravity of the policy making that is going to take place with regard to adopting or rejecting these rules. So I would just, you know, there's little, if anything, to disagree with the way that the hearing officer has represented her role in this process, and I will represent to the board that it fully complies with this board's rules and with this board's appointed authority.
Thank you, Ms. Solaria. And Member Garcia, I know you've had your hand up, and then we'll go to you, Member Honker.
Madam Chair, I know this is you know, we're a new board. A lot of the things we're going through are new to us as a new board, and we're learning new processes as we go along. And I think this is a big one. This is, I must say, the hearing officer's work is impressive. And I think that we, in our discussions about how to go through this in the most efficient manner, I think that's our task before us today. And in that regard, let me ask the hearing officer a question, if I may. I noticed in the attachment on page 11, number 1, you posed the question that the board could reject the proposed rule wholesale. I guess the board could reject the proposed rule, but I noted that you did not pose the opposite question, not that I'm suggesting it, but the opposite question, which is whether the board could adopt the new latest version, January 20th version of the proposed rule as is. That would be the opposite. And I noticed you didn't pose that. And I'm wondering, is there a legal reason why that is not an option for the board?
Thank you, Member Garcia. What I was doing there was signaling, if you will, or marking the decisions that the parties wanted you to make that I discerned in their post-hearing submittals. And really, how can I say, signaling to your board counsel and the rest of you that these were questions some parties wanted you to take up as part of your deliberations, and you may think it made sense to take it up before you get to the rule provisions. What I was trying to do in attachment A was distill the parties' final decisions as to each rule provision. But again, you have parties suggesting that you shouldn't deliberate on the rule provisions at all. And that's not something I would put in attachment A, because attachment A is focused on rule provisions. But I did want to point to those issues in the post-hearing submittals because the parties raised them in their final arguments to you. And it's important that you know they're exhorting you to reach certain conclusions in their closing arguments.
Thank you, Ms. Orth, and Ms. Member Garcia. Did you have any follow-up on that?
Well, thank you. Thank you, Ms. Worth. I think I heard in your answer that I understand why you posed it that way. However, there would, in your answer, what I'm getting is that there would not be a problem if the board were to look at the question of whether or not to adopt the rule, the latest version of the rule. It wouldn't be a problem to at least look at that legally.
Right. So we're flirting here with the line between what I was trying to do and Ms. Solaria's task. So let me mute myself.
Yes. Thank you, Madam Hearing Officer. To your question, Member Garcia, the way that the question is posed in the hearing officer's report is merely to bring that possibility to the board's attention, is how I interpret it. The board can proceed to adopt the language it sees fit to adopt. So it is, in theory, a possibility that the board can just adopt what's been the final proposal of the department. That is an option. You're entitled to do that, of course, with citations to the support and your rationale for doing that. I don't expect that to be the case given the controversy for various sections, but you are legally entitled, if that's your question, to adopt the rules as is, provided you provide a rationale, and the rationale would be subject to whatever support or challenge that rationale is entitled to.
Ms. Loria, thank you very much. That's all I have. Thank you.
Thank you, Member Garcia. And I want to go to Member Honker. I apologize. I know you've had your hand up for a while.
Well, I was going to try to reframe this in terms of what we do have, and I think it just fits with the discussion we just heard. The department's the petitioner here, and I think on most of these issues we're going to have to deliberate on. They have considered all the viewpoints from the other parties. In a lot of cases, they've addressed and told us why they don't recommend we do what a certain party wants to do on a rule. So we do have that. So instead of a hearing officer's recommendation, we have the department's recommendation on what to do on each one of these issues. And I see that as our starting point, that here's the petitioner, here's what they want to do finally, here are the other viewpoints, what do we want to do? So I think we kind of have what Member Cates was wanting, but it's from the department, it's not from the hearing officer.
Thank you, Member Honker. Before we go to Vice Chair Davis, I just want to maybe swing back around, Member Cates, and just hear your feedback on some of the other discussion items we've heard.
Well, what Member Honker said is, that makes me feel better, but we are still looking at a very daunting document here. And I go back to, isn't it possible to condense this in a document that just focuses on the points in contention? But I guess it's all here in this, and I'm not sure who's going to guide us through this. I guess maybe that's going to be you, Chairman Sweeney, but okay, yeah. So, but I mean, I expressed the way I felt about it, and I do feel better hearing Member Honker point out that the department has made a recommendation. So, yeah.
Thank you, Katz, or Kate's, I, I just want to address your concern as well, as we delve into this very large task as we've started this discussion. And I think what I want to make sure we all do, and I just want to get this on record, is that procedurally, all of the I's get dotted, T's get crossed. So for those types of procedural issues, we're going to really rely on our legal counsel to make sure that we have a good process and that we get everything documented. And it's going to be a team. We have our court reporter to make sure that our discussions are documented as well as our votes. And I know we're still virtual, so we want to make sure that we get everybody's input. All the board members are essential to this process, and your insight, your perspective, your expertise. And I think that's the beauty, but also the challenge as we move forward regarding this very daunting task, I think was referred to earlier. And that said, is we all sat through, most of us, through 2 weeks of a lot of information and experts and public input, and then afterwards ended up reading as well a lot of that information. So I want to echo your feeling of it's a lot, it's overwhelming. I know I felt like I've lived, breathed, and slept this since the hearing started, well, even before the hearing, and starting to look at some of the submittals, as many of us have. So I just want to make sure we're good as we move forward. It's going to be, Pam is going to help, Ms. Jones is going to help us on all the logistics, like what happened this morning. I was stressed too, trying to get in, trying to figure out which password to use. So again, we apologize on behalf of the team and everybody. I even had those issues. And so I also want to just put out there, as we deliberate today, it is a lot of information. If there's a point where we're confused, please raise your hand. Let's talk about it as we go through this. If there's other concerns, please raise your hand and let's talk about it. I just want to make sure we delve into this. And one more follow-up as I'm talking about this is Ms. Solari had brought up about our schedule. This afternoon, I would really like to, depending on how quickly or how slowly, how the progress goes for this first part today, probably this afternoon, I would love to have all of us have our schedules available. And Ms. Solaria had informed me that we have an April 25th deadline. Is that correct, Ms. Solaria?
Correct. The board has 60 days to make its decision. I am going to interpret that, for the sake of the separate task of drafting the statement of reasons, that is the board has to vote by that date, and then there's some additional time to prepare the statement of reasons. So that's really the drop date we're looking at for you to conclude your deliberations.
So we hope, members of the board, we hope that they're efficient. As I know, I've reviewed the hearing officers, hard copy report and pulling it up on the electronic platforms. In case we will need more days, let's just have our calendars available later on this afternoon. And we may have to talk about that. But let's start the process and see how it goes. And then to your point, member Kate's, that what I had talked with hearing officer is how can we efficiently go through this process so that we're transparent also with the public. I know many of us probably have the electronic version, the hard copy version. I have mine all tabbed and written on, but our members of the public and those following us on our discussions, she's gonna be able to put it up on the screen so we all know what sections we're talking about, if that helps us members of the board as well. And we are all open to any other efficient ideas for efficiency on the discussions and so forth. So I just wanted to frame that, and I want to thank you, Member Honker, for putting that other framing of the recommendations from the department. That is helpful as well to have that that highlighted, if you will, because there is a lot of information as well. And then I think Vice Chair Trujillo Davis, did you have another comment before we go further?
I did not have a comment about this particular issue. I was noting that we have an echo that is popping up every now and then. And so just want to advise everybody to be cognizant of your mute and unmute so that way we can all listen intently to what whoever's talking.
Thank you, Vice Chair Trujillo Davis. All right. And then with that, I guess we will. Is there anything else, Ms. Solaria, that we did not mention here at the beginning?
I don't have anything else, Madam Chair, and I will be with you through this. So that's all I've got.
Thank you. And I just want to do kind of a time check so that we're all looking at our schedules, even for today. So we'll definitely have a lunch. You know, we need some brain food to get through this process. So we'll have a lunch, and depending on where that falls into, someone between 11:30 to 1, depending on, you know, when we take lunch, on where we are on our deliberations and how the board feels. So I'm going to really look to our board members to help chime in about that. When you feel like you need a break, if we need a 5-10 minute break, either this morning or this afternoon in between our before or after our lunch break. So I just want to throw that out too. We need to move around a little bit, keep the blood flowing so we can get through this. So with that, I just want to check one more time with our members. Is everybody ready to go? Yes, Vice Chair Trujillo Davis.
Do you mind if we do a bio break about mid-morning or so when we get about, when we find a good stopping place there?
Absolutely. I know I've been drinking coffee, so I'll need it too. Thank you for that, Vice Chair Trujillo Davis. All right. So as we get into this, and I'm going to look to Ms. Orr. So we have the hearing officer's report, as we had discussed, and I'm going to look to the board too. As Ms. Orth mentioned earlier, there's a couple of kind of overall considerations that if we want to talk about them here before delving into the section by section. I just love to hear your thoughts on that and if that's a good way to go. Think that's good? Okay. All right. Miss Orth, would you mind putting up your hearing officer report to the section where we're talking about the overall kind of considerations that we briefly touched upon earlier?
Okay, I'm sorry. I had all the sections of attachment A ready to pull up.
Madam Chair,
Yeah.
Chair, may I make a suggestion that one of the initial issues actually has to do with 20.2.50.2, and that's referring to the scope of the rule, and that's right at the top of the attachment. So I think we'd be fine if the hearing officer could share that with us instead of the prefatory the report itself.
Thank you for that recommendation. Let's go there. Great. So on that section, members of the board, as Ms. Soloria pointed out, 20.2.50.2, which is the scope, this part applies to sources located within areas of the state under the board's jurisdiction that, as of the effective date of this part or any time thereafter, are causing or contributing to ambient ozone concentrations that exceed 95% of the national ambient air quality standard for ozone, as measured by a design value calculated and based upon data from one or more department monitors. So I won't read as further there, but well, actually, let me do that. As the effective date, sources located in the following counties of the state are subject to this part: Chavez, Donna Ana, Eddy, Lee, Rio Arriba, Sandoval, San Juan, and Valencia. So to our members of the board, this is one of those overall questions that we need to discuss and kind of begin our decisions really about. And before I chime in, I want to really look to members of the board to see what your thoughts are regarding this particular section. Yes, Member Honker.
I'll lead off. I think the big question here is the counties, whether Rio Arriba and Chavez County are included. I have read all the arguments either way. Counties are an unfortunate way that we're dealing with this. And I think NMED acknowledges that. Unfortunately, airsheds are not like watersheds, so you don't know exactly where the air is going to go. Could go any direction. I think it's very reasonable to rely on modeling to see where impacts are coming, where you have data points. My experience in the air program is you're always frustrated with a lack of monitoring stations. It always seems like there's never enough of those. But we discussed modeling extensively. We heard several experts on modeling. I didn't hear of any fatal flaws with NMED's approach to modeling. I realized that the counties are in kind of it's a political construct that is being used to designate where does this apply. But on the other hand, when I was a regulator, I heard a lot of, we want a level playing field from industry. But in this case, it sounds like some of the industry doesn't want a level playing field in those two counties in terms of what the requirements are. So on balance, I feel comfortable with the department's final recommendation to include those two counties. So I just want to put that out there as my thought on that issue.
Thank you, Member Honker. And yes, Member Duval.
I want to just completely agree with Member Honker. I as somebody that studies greenhouse gases, yeah, like the political boundaries do not, ozone precursors do not respect political boundaries, I guess is the way to say it. And I think I found, and I'm, as someone that's done a significant amount of modeling work, I found the argument compelling, and I would agree with Member Honker 100%.
Thank you for that input, Member Duval. And yes, Member Garcia.
Thank you, Madam Chair. I also agree that, the modeling did show that the the threshold is met as far as registering or contributing to ozone design values exceeding 95% of the NAAQS. Also, considering I'm keeping in mind that this is part of the ozone attainment initiative by the department, this rulemaking, and in trying to make sure that all the counties, if there's coming into 95% of the NAAQS, that measures are taken to keep it under. So I agree that Chavez and Rio Arriba County should go ahead and stay in. The other thing is considering that if they weren't brought in now, if they were brought in later, it would take a whole new rulemaking to bring them in, which does go through quite a lot of time. So considering the urgency of the issue and trying to stay under the 95% of the NAAQS, then I think it's appropriate to leave them in.
Thank you, Member Garcia. And any other members have any other comments and perspectives on this or discussion item or discussion on this? Yes, Member Bitzer.
Part and parcel here also is that there have been some proposed modifications to the scope other than deleting the counties. If I'm reading this right. Deleting are causing or contributing to, and then adding the word have ambient ozone concentrations. And then after concentrations based on data, that full paragraph. Based on data submitted by the department to EPA's air quality system. Anyway, are we going to consider those modifications as well?
Yeah, yes, Member Bitzer, I think really, all of the considerations are on the table here based upon what has been submitted by the various parties. And so again, I just want to make sure we go through this discussion on this overall here. Do you have any additional thoughts on that? Maybe Member Bitzer? Oh, you're on mute.
Sorry, I'm sort of on the fence at this point, interested in what others have to say about that. Thank you.
Thank you, Member Bitzer. Yes, Vice Chair, did you raise your hand, Vice Chair Trujillo Davis? Okay.
Well, I'd like to thank all my fellow board members here for their thoughts. You all brought up some really good points. I kind of want to combine Member Garcia's thoughts and Member Bitzer's thoughts on this about if you were to add counties requiring an additional rulemaking process. And I'm wondering if by adding this language that IPAN has proposed, that if it would require an additional rulemaking process, or it would create an on-ramp for counties that begin to exceed 95% of the national ambient air quality standard to roll into this rule. So I'm both proposing a question and kind of adding that to the discussion here.
Thank you, Vice Chair Trujillo Davis. With that, do any of the members have any thoughts on the discussion? Yes. Member Honker?
Yeah, IPA&M's proposed language change or addition based on the data submitted by the department to EPA's air quality system. I just don't know. That kind of sounds like it might be a subset of the total data that's available. And I can't remember if there was discussion on that point during the hearing, but I wonder if we add that language, if that would rule out some data from consideration that should be considered. So I'm leaning towards not including that. The department didn't propose to include that, and I'm not sure what the impact would be if that clause was included.
Thank you for that, Member Honker. Any other discussion on that? Yes, Member Bitzer.
Oh, at the end, IPA, I think NM saying this interpretation is in direct conflict with the plain language of the statute and should be rejected. Does council have an opinion on whether that's an appropriate statement?
Yes, thank you, Member Bitzer. Ms. Solaria.
Well, that goes to the crux of the dispute here, Member Bitzer. Industry and the department clearly have different interpretations of what the statute allows, which the hearing officer has excerpted what is essentially their purely legal argument in that section of the attachment. And I have my own, I'm not sure my personal thoughts on which reasoning is better, is useful or appropriate for the board. I will just again repeat that this is a legal question as to whether it is a question of law, whether or not the board has authority to apply these rules to those two counties. And the department has said that it's valid under their interpretation of the Air Quality Act, Control Act language, and industry has said that it's not. And it's a discussion over whether the statute's reference to within areas of the state, if we can frame it the way the department proffers, which is how they've framed it versus how industry has framed it, and they've stated that you have to look at this county by county and the monitoring values per county. So I hesitate to. It's not my place to endorse either legal interpretation because that is the question of law that the board has to decide.
Thank you, Ms. Solaria. And I think this brings up a good point as we start these areas where we have a question of law and interpretation by the multiple parties, which I think there's some other points in throughout these this information and our deliberations that will come up. But for this, Ms. Solaria, maybe a follow-up question to Member Bitzer's, and thank you for hitting the crux of the issue on this one, Member Bitzer. So these questions that are questions regarding interpretations of law, say we make one decision, what is that process if it's an interpretation of law, like in this case, the department?
Right.
Thank you.
I'll preface this by saying that not all questions regarding the board's authority under the law are alike. So there may be issues that arise during deliberations or throughout the rule where my advice would be different, where I would say, this is a clear cut, or it has to do with the board's process itself. And I would advise that the process that you are undertaking or avoiding is not in compliance with your statutory duty. So I did want to preface that to say that it's not that I am shirking my responsibility to give you legal advice. This issue goes to a question of law that would be subject to appeal. And I think really the kernel underlying your question, Chair Sweeney, is what's it going to take to get your decision overturned? On appeal to the Court of Appeals, a decision by the board would be upheld unless arbitrary and capricious, not supported by, I don't want to paraphrase the law, is not supported by evidence in the record or is arbitrary and capricious. And certainly acting outside of your statutory authority would be potential grounds for overturning the board's decision. But it gets us back to the same question, because the department is arguing that you do have statutory authority to do this. Industry is arguing that you don't. I will say that I think both arguments are within, they are not, what's the word I'm looking for? They're not frivolous arguments. So they're not frivolous legal arguments. They both, if we're looking at a broad spectrum of legal arguments, I think they're well within the boundaries of what is a non-frivolous legal argument. So I think the board is within its authority to weigh either one. I think if it was I think that's a good way of looking at it. If I thought it was a frivolous legal argument, I would say so.
Thank you, Ms. Solaria. And before I say anything more, I'll go to Member Garcia.
Madam Chair, I just also am thinking about whether we're setting precedent and what kind of precedent we would be setting, aside from the question of whether it would be overturned in Court of Appeals. I think the interpretation by NMED may be consistent with the way they've interpreted the Air Quality Control Act, and I wouldn't want to go against the precedent and set a new precedent. That's all. Thank you.
Thank you, Member Garcia. Appreciate that input. Yes, Member King.
Yeah, just a question here. So NMED's position on this particular point, is it encapsulated in this document, this appendix? Or is this something that council will have to, draft from other sources or from our comments? Is it in here?
Yes, Member Cates.
And I will just add,
I'm sorry.
Chair Sweeney, that it's included in the hearing officer's attachment because it was included in the parties' closing arguments and proposed statement of reasons. So the parties have done the heavy lifting of distilling their own arguments. The hearing officer did the additional, weeding through all of that to compile it this way. So the goal is that eventually when I draft the statement of reasons, that I wouldn't be doing that strictly from scratch. I wouldn't be, weaving out whole cloth. I would be excerpting parties' proposals that the board has endorsed.
Yeah. Well, so where is it in this document? Forgive me, I don't know where it is. I can't see it. Does anybody know?
So it's shared on the screen,
It is,
Member Cates. Yeah, so it's shared on the screen under 20.2.50.2, and that is page 1 through 7 of, or no, 1 through 6 of the attachment contains references to the parties' legal arguments.
Okay, so there's no place where it just stands alone in encapsulated form. It's just kind of referred to throughout these 6 pages.
Yeah, but that is encapsulated form because those were excised from the parties' longer closing arguments and proffered statements of reasons.
Okay,
Does
thanks.
does that make sense, Member Cates?
Yeah, thank you.
Okay. You're welcome. Just want to make sure we're all on the same page as the page is on the screen. So with that, members of the board, any other discussions? I wanted to be, I also, if there's nothing right now, I just wanted to maybe clarify if I can in this, with Ms. Solaria. So right now we have a recommendation or a, stated excerpt position here from the department, as Member Garcia mentioned. And this is based upon their interpretation and their legal counsel's interpretation. And so with that, though, in the information we've been provided, there is that basis and statement of reasons for their interpretation as well.
Correct. And so, and this goes to the larger process you all are tasked with. When you all are ready to take a vote on this, ultimately your vote will be for option A or B or C. You would state what the language that you are voting on, and you would refer, it could be something like, for the reasons offered by the department in their exhibits and closing arguments or statements of reasons, or vice, if you're going with industry's proposal, for the reasons stated, proposed by whoever it is. So that's how we would navigate it. And as I mentioned, that you could reference whatever has been included in this attachment, because those references itself includes an attachment to the record. So for example, there are explicit citations to parties' closing arguments, the transcript, and you could just refer to those as your rationale, to the extent that you endorse that rationale.
Thank you, Ms. Solaria. And Member Bitzer, and I saw your hand up.
Oh, I'm hearing some consensus about keeping the two contested counties in the language. Are we supposed to also, in a single motion, decide whether the additional or the substitution that Kinder Morgan has proposed, where they delete are causing or contributing to, and add the word have for ambient ozone concentrations? And then the one that IPA and M is proposing, a dependent clause basically that says based on data submitted by the department to EPA's air quality system. Is that all? Are those all supposed to happen in a single motion? Are we going to consider all of that?
Go ahead, Ms. Solaria.
That's up to you how the board wants to craft its motion. It may be cleaner to just do it to consider the inclusion of those counties first, and then to take up the additional language proposed, I believe, by, I think it was IPNM and again. So that's up to you. It may be cleaner to just do it that way, or you can talk, you can talk amongst yourself how you want to craft the motion, because ultimately if it comes out that you don't want to consider those additional language discussions, the motion would be just to accept the language as the department proposes it, if that makes sense. So you can hash that out in your discussions, how you want to, if you want to piecemeal it or take it up separately.
Thank you, Ms. Solaria. Yeah, yes, Member Hunker.
Yeah, just wanted to point something out with Kinder Morgan's proposed change. The way I read that change, it would basically take modeling out of the process and say you have to have a monitor site, which that doesn't fit with what the department proposed, and made that seems like it would undermine the two counties position. So I'm not comfortable with that change. I'm not crazy about the other one either. So I mean, I would be fine making a motion to adopt the department's language and rationale as they have proposed it on this section.
Thank you for that input, Member Hunker. With that, I'm just looking to members of the board. What's your thoughts if we're at a point now where Member Hunker could make a motion, or if we wanted more discussion?
I second Member Honker's motion.
Okay, so since we're just looking at the other board members here, Ms. Soloria, so this is going to be our first big motion here. So can you just provide some input as to what we need to include in that motion?
I actually think Member Honker did a pretty good job in his proffered potential motion, which would be to say the motion would be to adopt 20.2.50.2 as proposed by the department for the department's proffered rationale or offered rationale.
Thank you for that, Ms. Laurie. Yes, Member Honker.
Let me amend that because I think we have to take action on 20.2.50.1 as well. So let me just say, I would move that we adopt 50.1 and 50.2 as proposed by the department for their proffered rationale.
I'll second that.
Thank you, Member Honker, for your motion, and a second from Member Bitzer. With that, is if there's no other discussion on that point, I want to look to Ms. Jones, and I apologize for this added step, but we're going to do a roll call vote on that motion. Ms. Jones.
Yes, Madam Chair. Okay, on the motion on the, before everyone, Member Bitzer, how do you vote?
Oh, yes.
Member Cates?
Yes.
Member Duval?
Aye.
Member Garcia?
Yes.
Member Honker?
Yes.
Vice Chair Trujillo Davis?
Yes.
Chair Sweeney?
Yes.
Madam Chair, the motion passes.
Thank you, Ms. Jones. Appreciate that. All right. One down, and here we go. Appreciate that discussion from our board members, and I see our hearing officer getting to our next section here. We are on page. Sorry, I'm trying to figure out where we're at here too. What page are you on? Sorry, there's no. All right. Here we are. Okay. So are we at this next section?
Page 8, Madam Chair. I'm sorry, when I broke the attachment A into 12 different parts, the page numbers didn't translate. But this is page 8 and it's section 3.
Okay, thank you so much. Appreciate that. So would this be section 20.2.50.3, which is the statutory authority? And this is the Environment Improvement Act, section 74.1-1 to 74-1-16, NMSA 1978, including specifically paragraph 4 and 7 of subsection A of section 74-1-8 NMSA 1978 and Air Quality Control Act, section 74-2-1 to 74-2-22 NMSA 1978, including specifically subsections A, B, C, D, F, and G of section 7-2-5 NMSA 1978 as amended through 2021. So in this section, we have section 2.2 or 20.2.50.3 is a mandatory section for all rules promulgated by New Mexico state agencies and identifies the enabling legislation that authorizes the issuing agency to promulgate the rule. Section 20.2.50.30 lists the statutory authorities pursuant to which the board is authorized to adopt Part 50. The board should adopt this proposal for the reasons stated in NMED Exhibit 1, pages 4 through 5, and in NMED Exhibit 32, pages 12 through 13. So this is the rule, this is the section from NMED's submittals. Yes, Member Garcia.
Thank you, Madam Chair. Happily, it appears that this is not contested, as well as 50.4. I'm hoping that when we identify sections chunks that are not contested, that we could move to adopt them if we so desire together as a chunk.
And I just want to add to that, Member Garcia, we also have 20.2.50.5 as well.
Yes, you're right.
And
I meant to say
6.
that as well. Yes, thank you.
Yes.
And 6.
Well, is
It
that,
doesn't look like 6 is non-contested.
because Kinder Morgan wanted further
Oh,
clarification?
I'm sorry. That's right. They wanted something in the statement of reasons. Thank you.
Correct. So members of the board, with these sections, we have, I won't go into the reading again, but the section 3, 4, and 5 looks like NMED, everybody, there's no contention on this, or no parties are offering, looks like everybody is in consensus. With this, would you entertain could we entertain a motion to just, yes, Member Garcia?
Yes, thank you, Madam Chair. I would move that 20.2, 50.3, 0.4, and 0.5 be adopted for reasons, as reasons stated, with evidence stated.
Thank you, Member Garcia. Do I,
Second.
yes, Member Hunker seconds. With that, I'm looking to the board if there's any other discussion or questions. Yes, Member Bitzer.
This question for council, does the motion need to specify that it was for the reasons submitted by the department?
I think that's an appropriate amendment, Member Bitzer.
Friendly, I'll propose that as a friendly amendment.
Thank you, Member Bitzer. So,
Should I
yes, Member
restate it?
Garcia.
Okay,
Yes.
thank you, Member Bitzer. Good suggestion. So I move that 20.2, 50.3, 0.4, and 0.5 be adopted as with reasons stated by NMED.
And I'll friendly second that.
Thank you, Member Garcia, for your motion, and a second from Member Hunker. Is there any other discussion? If not, Ms. Jones, would you mind doing a roll call vote?
Here we go. Member Bitzer, how do you vote?
I vote yes.
And Member Cates, how do you vote?
Yes.
Member Duval?
Yes, aye.
Member Garcia?
Yes.
Member Honker?
Yes.
Vice Chair Trujillo Davis?
Yes.
Chair Sweeney?
Yes.
Madam Chair, the motion passes.
Thank you, Ms. Jones. Great. Well, we're gonna just zoom right in to 20.2.50.6, and just for time, I'm not gonna read it. We have it up in front of us. But it does look like NMED, or excuse me, Kinder Morgan desired further clarification in the statement of reasons. So I don't know if any of our board members have any discussion on this particular one. Yes, Member Honker?
Yeah, just a question, I guess, for council. So it looks like Kinder Morgan is not objecting to the language. They just want some additional language in the statement of reasons. So I guess our decision is, do we include that language in the statement of reasons, or just use the rationale proffered by NMED? Is that the decision we have here?
That's correct, Member Honker, and the position is as exerted there. Your vote would be, it sounds like there's no controversy over the language of the rule itself, but because Kinder Morgan has asked it of the board, and of course I would need the board's permission or direction to include that additional rationale, that is something that you would have to vote on, and you're free to direct me to include that, or you're free to rely on that, and you're free to not rely on that. That's your decision.
Thank you, Ms. Laria. Yes, Member Garcia. I think you're on mute. Sorry about that.
Now? Yes, okay, great. Thank you, Madam Chair. Yes, I read through their consideration, and I also remember this discussion during the hearing about the co-benefit of methane being reduced. I think that it's having some familiarity with environmental regulations. I think it's very unusual to write the co-benefit within the regulation itself. I think there are many environmental regulations that do have co-benefits, but you don't write down the co-benefits. You don't write that there are co-benefits. So I think that's a very unusual move. So I suppose for that reason, I would reject their proposal. Thank you.
Thank you, Member Garcia. Yes, Vice Chair Trujillo Davis.
I think if I understand this issue, and I'm very open to discussion on this, the issue is the term methane and the definition as it's defined by the EPA. And I am going to look to Member Honker on this in his thoughts on as to why we would, or why it was proposed to add the term co-benefit and the term methane.
Yes, Member Hunter.
I don't know that I can shed any big light on this, but my impression, I mean, if we throw a contaminant out there that this rule is not directly addressing through regulation, it seems like we're kind of muddying things up a bit. And that may be what Member Garcia was saying. But for instance, if EPA were to develop some new rules on methane or something now, well, what does that do to this rule if we finalized it and approved it? I think I agree with Member Garcia that while there is an apparent co-benefit here, pointing it out, I don't think is necessary and doesn't necessarily strengthen the rationale for this rule. I mean, the rule is what it is. So I think I agree with Member Garcia on that, and that's all the insight I have.
Thank you, Member Honker. Vice Chair Trujillo Davis, did you have a follow-up?
Yes, I think what I'm trying to ask, and I full transparency, I really not 100% on the answer to this, but is methane considered a criteria pollutant for NAAQS?
And I don't know the answer to that. So,
Yes, Member Bitzer, I think.
My recollection on that from the earlier discussion was no, but I would look down to Socorro for some expertise down that way. Professor, are you on?
Yeah, I can't speak to the NACs specifically, but you know, the the issue that I see here is that there are I mean, I agree with Member Honker that excuse me, that it could be muddying the waters a little bit, and one of the reasons why is that, you know, these are co-evolved situations, right? You're not going to you're not going to have ozone precursors without having methane release. I mean, these are you have trying to think of the right verbiage here. Basically, a community of gases that are being released from these scenarios. So, I mean, I could understand why, you know, methane might be included in here, but I mean, it's just part and parcel of having these venting issues. You know, it's not like it's just a single gas that's coming from these wells. So I think the cleaner the language could be, the better, because sorry, it's going to take care of you're going to have ancillary benefits, irrespective of what the language is here. If the rules in place, then some of these other things are going to kind of take care of themselves as well. Does that make sense? I mean, if you're proposing that there needs to be reductions of one thing, there's necessarily going to be reductions of others.
Thank you, Member Duval. Yes, Vice Chair Trujillo Davis.
First, thank you, Member Duval, for your explanation of that, and I don't disagree with that. But I think the issue here is that this rule and most of what we've seen throughout the rule is based on the National Air Quality Control Standards, which is your NACs, right? And those criteria pollutants listed in NACs, which a quick search don't include methane. So as we're talking the semantics of the language, and maybe semantics is too dismissive here, but I think when we start throwing in the term methane, you do start muddying the waters. And we are talking a lot about methane here. And so for clarity, I really think we should stick to the NACs criteria pollutants that are listed. And I just want to throw that out there to keep that in mind. So if we did adopt the language of Kinder Morgan, I would suggest that we keep that phrasing in there as a co-benefit, because methane is not a criteria pollutant.
Thank you.
Yeah, excuse me, Madam Chair. Yeah, Member Trujillo David. Yeah, I very much. If I was being a little bumbling in my words, I do agree with what you just said. I mean, I think that's the idea here is to make it as understandable as possible, and definitely sticking with established criteria is going to be of benefit for the overall aim.
Yes,
Madam Chair,
yes, Member Bitzer.
point for a motion, I would move to adopt 20.2.50.6 as proposed by the department for the reasons proffered by the department.
Thank you, Member Bitzer.
I'll second.
Thank you, Member Honker. There's no other discussion. Ms. Jones, would you do a roll call vote?
Yes. Member Bitzer, how do you vote?
I vote yes.
Member Cates? Member Duval?
Yes, I.
Member Garcia?
Yes.
Member Honker?
Yes.
Vice Chair Trujillo Davis?
Yes.
Chair Sweeney?
Yes.
Madam Chair, the motion passes.
Thank you very much. It looks like, but I want to do a check on with our board members. Does anybody need a quick break? We're getting into another section where we have, it looks like no challenges from the department or the various parties. Yes, member Trujillo Davis.
I would like a quick little bio break. We could do 10 minutes or so.
Sounds good.
Okay.
With that, let's come back at 10:55, 11 minutes.